At IPBC Asia 2015, here at the Palace Hotel in Tokyo, we are once again hearing a lot about NPEs, non-practicing entities, companies, in other words, which defend IP portfolios even though they don't necessarily own them. The less kind description, of course, is patent trolls, and that's where this dog comes into play. It's Kevin Jakel's dog. He's giving them away at his UnifiedPatents booth here. What's with the dog, Kevin? Tell us firstly.
Well, so we are a defensive entity and we protect technology areas from patent trolls. So in particular, we have a group of technology areas, cloud storage, content delivery, wireless, automotive is our newest zone, and we have Toyota and Honda are two public members of that particular zone. And the Bulldog represents an entity like ourselves that basically patrols that technology area and makes sure that patent trolls don't have an opportunity to monetize patents in that space as easily and efficiently as they would if we hadn't been there.
Yeah.
So essentially we are a bulldog in the space, and we send the message to anyone in our zone: go someplace else.
Yeah.
Otherwise, get bitten.
It's a cute way to represent actually a very serious message, which is, of course, that patent trolls still make a lot of people's lives miserable. Now, we'd have to be careful saying that at this conference, because clearly it's a spectrum of people who some might classify as patent trolls. Others will simply say, hang on, we're doing a legitimate business. How do you go about figuring out where you need to bite and where a bark is enough?
So I think it's a key point here, because NPEs I think is the more appropriate term. Patent trolls is obviously a negative term, and honestly we don't really have a problem with monetizing patents. What we do have a problem with is monetizing invalid patents or poor quality patents. There are lots of, unfortunately, poor quality patents, but it's very difficult to figure out which ones are bad and which ones are good. What high quality means is something that often requires litigation to figure out. Or alternatively now, there's a system at the USPTO where you can use the PTAB, or filing what we call IPRs, inter-parties reviews. We use that process in order to challenge patents owned by NPEs in the space or in a particular zone. We challenge those patents to try to see whether or not those patents should have ever existed in the first place. But we care more about patent quality, but we are a defensive entity designed to make it less likely for NPEs in those zones to, one, be successful monetizing them, and then two, to deter them from reinvesting in that technology area. We want NPEs, or entities looking to monetize patents, to do one of two things. Either make sure they buy patents of the utmost quality, and if they do, I can't touch them. I can't do anything about it. My bulldog is powerless. And we think that those are patents that companies should be in a position to license fairly. But if they come into a zone with a patent that is of low quality, we are there to help stop that. Or alternatively, our preference would be that entities just avoid our technologies altogether. If you don't want to run the risk of us getting involved, buy patents in technology areas where we don't protect, and we are perfectly comfortable with that.
How did you make this a career choice, to protect the underdog, so to speak?
Yes, well, so prior to starting Unified, I was head of IP litigation at a software company called Intuit, managing a docket of patent litigation. Unfortunately, it was probably 90% plus NPE litigation. And trying to basically manage that litigation with a bunch of other defendants who all had the same problem. All were essentially doing the same work over and over and over again. But because of the difficulties of working within joint defense groups, coordinating joint efforts, often the defense of fighting against a bad NPE patent was more expensive than it was to settle. And that is part of the NPE business model in our view. So Unified came out of an effort to group companies together in an efficient way, where Unified could be out in front, protecting a technology area in a very efficient and simple way where operating companies wouldn't have to do that same work over and over and over again. The repetition among different defendants could be eliminated, and Unified could do much of the work that operating companies often have a more difficult time doing quickly and efficiently.
So how are you different from any other attorney who simply defends against a patent troll or an NPE?
Well, so we're not, I am a lawyer, but Unified Patents is not a law firm. So we do not have a legal representation relationship with our members. We don't have an attorney relationship with our members. So we're very different in that we don't represent them specifically. We don't represent the other members of our zones specifically. What we ultimately do is hire lawyers ourselves and file IPRs to stop invalid patents as an independent entity. And so we're not bound down by the complications of working within a joint defense group. We can move more quickly and more efficiently. We can do prior art search early, and we are not coordinating among a large group of defendants on exactly how and when to file an IPR. We can move very quickly because of that. It's actually an advantage that we have, that we are not trying to herd cats to get a single IPR filed. One of the things that really makes us different is that we do not pay NPEs for licenses. And so we have a kind of deterrent effect where we're not contributing to reinvesting in NPEs, monetizing a technology area over and over and over again. We do not incentivize an NPE to successfully license a patent, take the profit from that, pocket some of it, reinvest in another patent, and sue you all over again. Serial litigation is part of what Unified here is really here to address, is try to discourage people from suing the same technology area over and over and over again. Our structure allows us to create a very unique deterrent that an individual attorney could never achieve on his own.
One of the other guests joining us here in the IPBC TV studio earlier was saying that actually the whole area of patent trolls is kind of on the way out, that it's a passing trend. Do you agree?
Well, what we do know is that there are certain market characteristics that have traditionally showed that there was a lot of NPE activity going to be happening. The secondary market is an area where we have seen a pretty substantial reduction in activity. The causes of that might be a recent case called Alice. The IPRs and the PTAB are certainly has had an effect on the overall market. Unfortunately, however, litigation is not necessarily dropping off. Our analysis shows that litigation in 2015 is on pace to be at least, if not more, than what we saw in 2014, which is only a drop off of the all-time high that occurred in 2013. Historically, we are still at an all-time high in terms of the amount of litigation. We've also looked specifically at the litigation taking place in the high-tech space, and even to this day, 80% of all the litigation, if not more than that actually, so sometimes it's as high as, on any given month, as high as like 90% of all the litigation in high-tech is based on NPE litigation. Patents being monetized either by individuals, companies, or special vehicles for monetizing the patent even though they don't practice it. While we don't have a problem with that model, we do think it is a cost in which we are here to be a counter to. Not that it's wrong or right, that is not our position, but we are here to help companies manage that cost and that risk, and do so in a way that makes them less likely to get sued again.
And presumably you're cheaper too.
I mean, there's no other company out there that does what we do in terms of creating this deterrent. We're significantly cheaper than other deterrent strategies, RPX being the most notable one. And I think the real big difference between us and RPX is that we don't pay NPEs for licenses. And while that's not necessarily a terrible thing to buy a license, RPX, by doing so, actually encourages that NPE to pocket some of the profit take some of it and reinvest in another patent and sue companies all over again. And we think that synergistic relationship is one that we actually have a solution to try and break.
And if you're really successful with it, you'll be doing yourself out of a job, hopefully.
Well, we disagree with that too, because we think that if we're really successful in one zone, another technology area is just going to pay us to do that for them too. So we think it'll be a very long time before we have zones open in every technology area and have wiped out NPE litigation for everyone.
But is that your vision? Is that what you're aiming for?
Well, we do want to open up zone after zone after zone after zone. We want to do this work on behalf of technology areas where companies are dealing with risk and want to find a way to break out of that cycle of litigation, settle, reinvestment in the technology area, litigation, settle, reinvestment. We want to break that cycle. And we think that Unified is a way that allows for the investment in at least bad patents to be broken. And if companies want to spend more money by really high quality patents, we are powerless to stop that, and we think that's actually a good, healthy thing for the entire patent system.
How do our viewers get involved in making your vision come true?
One thing that's unique is you can join on a per zone basis. So you can join our cloud storage zone, or you can join our automotive zone, and you pay on a per zone basis. And whether or not you like the technology area and you want to help protect it, the more money we have in a zone, the more work we do. And so companies actually pick and choose from a buffet of different technology areas that they care about. And the more money we have across those different zones, the more work that we do. So companies pick the technology areas they care about, and in doing so, we are then, have the resources to deter future investment in those spaces.
Thank you very much.
Thank you.
Kevin Jakel there from Unified Patents joining us here at IPBC Asia in Tokyo.